Where defendant Sarah Boone is due back in court tomorrow afternoon, filing new handwritten motions, adding to the mound of letters that she's already sent to the judge regarding her case. Boone is now requesting to have all discovery, currently on a USB flash drive, be put in physical format so that she can review them at any time. Another filing indicates that the judge needs to address her mail differently. She's also asking to be allowed to come to court unshackled so that she can function comfortably throughout the courtroom. Sarah Boone will be representing herself at trial after being charged with second-degree murder for allegedly zipping up her boyfriend in a suitcase and leaving him there to die. Court TV anchor Vinny Peloton has a closer look at this case.
911, what is the location of your emergency?
It's Monday, February 24th. There's a crisis at the home of Sarah Boone, prompting her to call 911.
Is this a police or medical?
My boyfriend is dead.
Okay, send a line for the fire department. Do not hang up.
The fire department takes over the call, and for the next few minutes, officials are obtaining critical details about what happened.
No, tell me exactly what happened there.
My boyfriend and I were playing last night, and I put him in a suitcase and we were playing, and like kind of hide and seek kind of thing. So I fell asleep and I woke up and he was dead in the suitcase. So I don't know what happened.
Okay, is he hanging from somewhere or what, ma'am?
No, I pulled him out of the suitcase. I tried giving him CPR.
Fire and rescue instruct Boone on how to give chest compressions.
Just keep on pumping. That's all you need to do for me. Keep on pumping his chest for me. I don't need you to stop and talk or anything. I just want you to count out loud for me, okay?
31, 32. Please hurry.
Okay, man, they're getting there as fast as they can, okay?
He's stiff and he's purple.
EMS arrived within minutes and advised Boone that her boyfriend, Jorge Torres, had been down too long and there was nothing more they could do. Boone explained she and Torres were drinking the night before and thought it would be funny if he got inside of a suitcase for a game of hide and seek. The next day, deputies returned and arrested Boone and charged her with second-degree murder in Torres's death. Boone's story about a childhood game gone awry unraveled when investigators say they found video on her cell phone showing Boone taunting and laughing at Torres while he was struggling to get out of the suitcase.
I can't breathe, babe.
Oh. That's what I feel like when you drink on me.
Sarah, I can't breathe, Sarah.
Yeah. You should probably shut the
When police questioned Boone the next morning, she seemed to have no memory of that happening.
I fell asleep, so I don't know if they suffocated her, or if I got an aneurysm or a heart attack or what.
Boone told investigators she only realized her boyfriend was still in the suitcase when she woke up. Still, investigators say her actions add up to murder. Sarah Boone has pleaded not guilty and maintains her innocence.
All right, I want to welcome our guest for this hour, criminal defense and civil rights attorney, Kesia Early. Kesia, thank you so much for joining us this afternoon to talk about this case and many others that we're covering here at Court TV. But talking about the Boone case, all right, she's going to be back in court tomorrow. I'm assuming she's driving this judge bananas because she has written so many letters to the judge, she's filed so many motions. This new one is she wants all the discovery in physical format. I know in one of her last motions that we reviewed, it talked about how she really didn't have access to internet. So truth is, if the discovery's on a USB drive, flash drive, she can't really access it all the time. So having it in physical format, I don't see that that's an unreasonable request. But what do you think?
Well, the problem is the majority of her demands were unreasonable. And, you know, although attorneys who do this for a living, we practice and litigate for a living, we make it look easy, it's not as easy as it looks. And if that was the case, then what would be the purpose of going to law school, being educated in the proper rules of procedure, the rules of evidence? And for her to go through so many attorneys and then put the blame on her previous attorneys, clearly the fault lies with her. Some of her demands are reasonable, though. so. And I do believe, considering that she will be representing herself, the court needs to make sure that the prosecutors in this case make sure her discovery is easily accessible. Obviously, she does not have access to a laptop, so placing all of the discovery onto a USB drive is unreasonable. But as far as not being shackled because she's uncomfortable, although you're innocent until proven guilty, had you allowed your attorney to fight for you and zealously advocate for on your behalf, there could have possibly been a better way to file these motions. So she's going up a very difficult uphill battle.
Casey, what do you think about this case in general? You have that cell phone video where she clearly knows he's inside that suitcase. Clearly, even the next day, she says to law enforcement, I don't know if he suffocated or if he had a brain aneurysm or a heart attack. I don't know. Well, clearly he did suffocate. I mean, that shouldn't be a surprise to her.
Absolutely, but here in Florida, voluntary intoxication is not a defense. So had I been her attorney, I would have tried to mitigate this from the onset. Sometimes you have a case where the facts are just bad. And although you're cloaked with the presumption of innocence and you do have the right to go to trial, you have to make a judgment call when there's so much circumstantial evidence, actual tangible evidence against you. In this case, it would be the video. The best possible defense in this case should have been possibly get a medical evaluation, get a psychological evaluation, and present mitigating circumstance and hopefully negotiate a plea resolution. But again, she was difficult to numerous previous attorneys, and now she lost her chance and has to represent herself with limited resources. So again, this is going to be very difficult on her behalf.
Difficult on her behalf, and yeah, the judges made it clear that we're going to go to trial in October no matter what, so she better get ready. We'll have to be watching this one. All right, thank you so much for joining us.